afternoon, Dominic.
Hello.
Thank you
Hi.
for joining me today.
Pleasure.
So we've got a few questions for you in relation to the trial witness statements in the business and property courts. I understand there's reform on the horizon, and in simplistic terms, I understand that these will impose more onerous obligations on legal representatives in commercial matters. Can you describe for us the key features of these changes?
Okay. Well, first and foremost, they are going to put an enormous extra obligation on practitioners, and partners, senior legal people are going to have to sign a certificate in these cases. We'll look at what cases are caught in a bit, but they're going to have to sign a certificate saying that they've done everything by the book. They've explained the law and the practice of witness statements to the witness, and that they in turn have prepared the witness statement in full compliance with the rules. So immediately there's going to be a lot more responsibility imposed. And if it goes wrong, the solicitor who signs this off, they don't sign it off in the name of the firm, they sign their own name, and there will be judges waiting to give people a great big kicking, is my view, if there is non-compliance. So this is majorly important.
Gosh, right, okay. So there's quite a bit of procedural change then.
There is.
What do you think will make the task of obtaining witness evidence particularly arduous?
Right, well, I suppose arduous and therefore expensive, or more expensive, is that in the past, you'd proof a witness, you'd knock out a statement, you'd send it to them. The new rules say at the very beginning, you must explain to them, the legal representative must explain to the witness what is in, what is out. You'll not have gossip or innuendo. It's got to be facts that they ascertain for themselves. The rules even say it's going to be something that you've seen or heard or smelt. We won't go into that one, or touched. So it is massive front loading. And my immediate warning is that the budget for witness statements can only go up. And because if you get the budget wrong, courts will not increase the budget simply because somebody miscalculated. It wasn't enough. The client will be, to use a very technical legal term, the client will be absolutely stuffed if they don't get the budget right. And so you must work in to the budget the additional expense of this exercise. And I don't think it's cheap or straightforward.
No. So I suppose those of us that draft budgets now need to start thinking about that and incorporating that if the witness statement phase is going to start, is going to take place after the 6th of April, which of course is the date that these reforms come into effect.
Yeah, it can be absolutely clear. You're right. So any witness statement executed on or after the 6th of April has got to be prepared in compliance with the new rules. So realistically, here we are, we're talking live in March, so reform in under a month. So it seems to be quite clear that people are already going to be thinking about these things now, because if the statement is not going to be ready before the 6th of April, then all the new obligations kick in and the extra expense is there, yes.
So going back to the cost budgeting angle, I need to be able to properly reflect just how labour intensive the task of obtaining witness statements for trial is going to be. Are you able to give maybe a broad indication of how much more? Is 25% as
you know what,
I should bear in mind?
That is just a mad, wild gamble. But I think one factor that I think would influence your judgment, and you're the expert, not me, is the fact that a senior legal representative has got to explain and at the beginning and to sign off at the end. Now, that doesn't mean that that person is going to do all of the work. I mean, broadly, preparation is a team effort. But what we're going to have, and we can't exclude, is the continuous involvement of your senior grade fee earner to ensure that things are done by the court. So immediately we've got that. And equally, courts aren't going to say, right, you can't have a grade A fee earner doing every single exercise and licking stamps. But it is always a team exercise. But I really I'm keen to point out that at the end of all this exercise, The person who's left holding the baby is the senior legal representative. So we need to work them into this process. And there's no avoiding it. I mean, the rules are absolutely clear that that person has got to explain, that person has got to sign off. And indeed then, as to content, I must say, I think the rules about witness statements have been ignored more than any other set of rules in the entirety of the legal structure. But that has got to change. And indeed, as an aside, even outside these reforms, I think that with the new emphasis on statements, judges are going to get a lot more tetchy, and they're going to say, this is not a valid statement, I'm striking it out, go away, do it all over again, bear the costs, thrown away. Yeah. And just on jurisdiction, to be absolutely clear, the rules apply to trial witness statements in the business and property courts. So it's not sort of personal injury or conventional Queen's Bench, but there, I mean, that's chancery, that's commercial. A lot of clarion work is bound to be in those areas. TCC, this is major, major work. Yeah.
Yeah. Okay. Do you think that do you think this pilot might be for wider adoption? I mean, is there any particular reason why it should be limited to the business and property courts?
That's a great question. I think the answer, first and foremost, let's come in from the other end. Why the business and property courts? Answer, because you've got a longer limitation period. It's not like personal injury. We've got 3 years. We've got these commercial cases, and something could come out of the woodwork 5 years after a transaction. Advice was given about, say, an investment, and so those cases, if you're trying to remember, and you're somebody in business, and you're trying to remember a transaction 3, 4, 5 years ago, you can see the problems, and they've really latched onto it there because they feel that documents. Now, there's a wonderful phrase from an American lawyer that contemporaneous documents are truth tellers. What was written in a memo or in a diary, that's pretty powerful evidence. But memory is susceptible to self-deceit, to variation. People not being fraudulent, although some are, but people just they want to do their best, and so it's really trying to get people to tell it like it is and not be influenced by material that's put under the nose, material they've never seen before.
Yeah, and that's the key, isn't it, really? And that's why.
Yeah. So coming back to your question, I think the answer is that absolutely first and foremost, business and property. It may, although I think it's over the top, frankly, for a lot of lesser matters and appear. Think about for example, an accident claim, a classic accident claim. We are looking at a single incident, whereas in business disputes, we could have had toing and froing for months about whether, what are the terms of the contract. So it is a different proposition. So I don't think that anybody should panic yet about this becoming universal. And it is a pilot. And if we know from the disclosure pilot scheme that these things have a long, slow burn. So, but it's coming in all business property courts with a bang, and it's going to be big stuff. Yeah.
And all commercial litigators need to be alive to the fact that they should wrap up their witness evidence now if they're in the midst of it.
Yeah, well, you're right. I mean, the best tip of today, I fear, is going to be if you can get your statement served, executed before the 6th of April, bingo. Because if it's the 7th of April, you're going to have to start all over again, because you're going to have to comply with the requirements from the outset about explanation. So there is going to be a massive gulf between the old and the new. Yeah. Just one exclusion. I mean, there are some ragbag exclusions in the regulation. I'm going to be doing a talk for Clarion soon anyway about the nitty gritty. But Part 57, probate claims, inheritance claims, things about personal references, they are excluded. Yeah. For the moment, yeah, they're excluded. But otherwise, all business property work, apart from one or two odds and sods, will be bought by the rules. So it is a really, really big deal. And people drafting, I say anybody drafting a bill, drafting a budget, sorry, really does need to factor in this extra expense. And I think any argument about costs, it's unarguable that one is saying well, these are the numbers, and this is what we've got to do. It can't be done any other way.
Brilliant. That's been really insightful. Thank you. I think that's all questions I had for you, actually, but if anybody else has any questions, please contact us via the usual channels. Thank you.
All right. Thank you. Bye-bye.